Imagine this. You were walking through a parking lot and all of a sudden a driver hits you. Maybe they were backing out without looking, or maybe they were on their phone. Either way, now you're hurt. Their insurance is already calling you, and now you're trying to figure out what to do with this case. Here is what you need to know before you say anything to anyone. I have handled several parking lot injury cases across Baldwin County, Mobile County, Jefferson County, other counties in Alabama, and the same mistake comes up every time. People talk to the adjuster without knowing what they're about to walk into. Most parking lots are on private property. That means that the standard traffic rules, they don't apply as they do on public roads. There's often no police report, no citation, and no formal investigation of what happened. But the drivers out there, they still owe you a duty of reasonable care. Alabama's negligence laws apply on private property. Without a police report, that burden to prove what happened falls on you, and what you documented yourself in that window, it closes fast. For example, this is where that surveillance footage and preserving it very quickly matters, because that surveillance footage will be overwritten within a matter of 24 to 72 hours. Fault comes down to whether the driver exercised reasonable care or not. Here are a few factors that matter most. Was the driver backing out without looking? Well, they're required to yield to pedestrians in the travel lane. Was the driver on the phone? Well, that supports wantonness. Was the pedestrian in a marked crosswalk or walkway? That strengthens who had the right of way argument. And did that pedestrian just step out between parked cars unexpectedly? That's where fault analysis can get complicated. In most states, shared fault only reduces your recovery, but in Alabama, it can eliminate it entirely. And that is the next thing we need to talk about. Alabama is one of the very few states that still follows pure contributory negligence. What that means is that if you were just even 1% at fault in the accident, it completely bars your claim from recovery. Not reduced, barred. Insurance adjusters know this rule and they are trained to use it. In parking lot accidents, they're looking for anything they can point to put fault on you, even partial. You were looking at your phone. You were walking behind a car that was backing out without checking. You weren't in a marked crossing. Even a weak argument is worth making from the insurance company's side, because if it sticks, your entire claim is gone. And this is why the conversation that you have with the insurance adjuster in the first 24 to 48 hours, it matters so much. You are not required to give a recorded statement to the other driver's insurance company. So do not give that statement without first talking to a personal injury attorney. Ideally, we want you to call us right away, right after the accident happens, so that we're there with you and we don't let you walk into that trap with the insurance adjuster. There is one specific situation where the contributory negligence rule can be overlooked, and that's when the driver's conduct rises to the level of what Alabama calls wantonness. Wantonness means a conscious disregard for the safety of others. A driver driving under the influence of alcohol or drugs, a driver that is distracted by his cell phone, someone that is speeding through a parking lot without any regard to those pedestrians on foot. When wantonness applies, two things change. The insurance company's argument for contributory negligence becomes a lot harder for them to use, and punitive damages may become available on top of your actual losses. If the driver was impaired or was engaging in any form of reckless conduct, that needs to be part of your evaluation before you make any decisions about your case. We have seen offers that are low in DUI cases where the pedestrians got hurt, and those offers did not reflect punitive damages at all. This is what's important. That first offer is never going to reflect the full value of the case. And that's what this free consultation is for. If you were hit by a car in an Alabama parking lot, here's what matters most. Get medical care immediately. Adrenaline will mask your pain, and the gap in treatment becomes a gap in your case. If you're still at the scene, take pictures of your injuries, the parking lot layout, any cameras for surveillance, crosswalk markings, and pictures of your vehicle. If you cannot do this at the scene of the accident, go back and ask every business in that area for surveillance footage and ask for it to be preserved immediately. Do not give a recorded statement to the other driver's insurance company without speaking to a personal injury attorney first. And last, check your own auto policy for MedPay and what's called underinsured motorist coverage. If the at-fault driver carries minimum limits or no insurance at all, and your injuries are serious, this MedPay UM/UIM coverage can help you a lot. And know your deadline. Alabama has a statute of limitations for injuries such as these, 2 years from the date of the accident. Personally, I would not wait to take all of these steps. Any delay can really hurt your case if it happens in a parking lot. So if you were hurt in a parking lot and you are trying to figure out your next steps, call us. Our conversation is free. We will give you honest feedback and we will not push you into something that is not in your best interest. If this was helpful, don't forget to subscribe. Drop your questions in the comments below. And don't forget to come back for our next video. It's about how cell phones can be used as evidence in your case. Thank you for watching.